Ma'am, you need to stop resisting and get on the ground.
I'm standing still with my hands
You're
visible.
being belligerent. Get down now.
Officer, I'm a sitting federal judge. You're making a serious mistake.
I don't care who you think you are. On the ground.
My hands are empty. I'm not a threat, and your camera is recording this. But understand that every second of this is being recorded, and you're violating clearly established law.
The security camera in the parking facility recorded everything, each utterance, each gesture. And Officer David Hutchkins possessed absolutely zero knowledge that the individual he was preparing to restrain had dedicated the previous 19 years seated on the federal bench overseeing cases concerning police misconduct, civil rights breaches, and Fourth Amendment violations. The individual positioned beside the black Mercedes was not experiencing panic. She was not shedding tears. She was not pleading. She was Judge Kesha Langford, and she had condemned corrupt law enforcement officers to incarceration. She had delivered rulings on qualified immunity matters. She had authored legal decisions that became binding precedent across 3 states. And presently she was preparing to become the complainant in a legal action that would cost the municipality hundreds of thousands of dollars and terminate multiple professional careers. Before we explore deeper into this utterly shocking narrative, I require you to do something. Post a comment immediately and inform me of your viewing location, your nation, your province, wherever you happen to be. And if you support holding authority figures responsible when they misuse their power, press that subscribe button. This narrative becomes even more compelling. You do not want to overlook what transpires next. Kesha Langford was not an individual who anticipated preferential treatment. At 52 years of age, she had served as a federal judge for almost 2 decades. She had managed death penalty proceedings, organized crime prosecutions, and intricate civil rights litigation. She was impartial, meticulous, and recognized for holding both prosecutors and defense counsel to the most rigorous standards. That Saturday afternoon, Judge Langford had been conducting shopping errands. Nothing out of the ordinary, nothing questionable, simply a routine weekend errand excursion. She had visited a premium outdoor shopping center in La Jolla, acquired some merchandise for her residence, and was placing shopping bags into the trunk of her Mercedes when everything deteriorated. The automobile was hers, correctly registered with current registration tags. She held the key fob in her hand. She was attired in casual weekend attire, jeans, and a blazer, nothing ostentatious. She was executing precisely what thousands of individuals do daily in parking facilities throughout America, loading acquisitions into a vehicle and preparing for departure. Then she detected the voice from behind her. "Ma'am, move away from the automobile." Kesha rotated around. A San Diego law enforcement officer was advancing toward her, hand positioned on his service weapon, not withdrawn, but resting upon it. A stance of preparedness. Officer David Hutchkins was 36 years of age, 8 years with the force, and responding to what he believed was a suspicious individual call. Someone had communicated a report about a woman behaving suspiciously near expensive automobiles in the parking area. The description was ambiguous. Black female, medium build, near a black Mercedes. That was the entirety. No description of suspicious conduct, no notification of attempted theft, simply a black woman near an expensive automobile. Hutchkins had determined that Kesha was the suspicious individual. Kesha maintained her hands visible, one still grasping her key fob. "Is there an issue, officer?" "I require you to move away from the automobile and present me with some identification." Kesha's legal intellect immediately recognized what was transpiring. This was a Fourth Amendment seizure. Hutchkins had detained her without reasonable suspicion of criminal conduct. She had 2 options: submit and resolve it subsequently, or assert her rights at this moment. She selected assertion. "Officer, I am loading my personal car with my personal acquisitions. I possess the key fob right here. What reasonable suspicion do you possess that I am participating in criminal conduct?" Hutchkins did not appreciate the inquiry. Most individuals he stopped did not pose questions, they simply submitted. "Ma'am, I am investigating a suspicious individual report." "I must see your identification." "What particular suspicious conduct was reported?" Kesha inquired. "Because loading shopping bags into an automobile is not suspicious, it is ordinary." "Someone contacted with a report. A report of what particularly? What offense do they suspect was being perpetrated? Hutchkins's hand constricted on his weapon. Ma'am, you must cooperate. I am cooperating. I am requesting you to articulate the legal foundation for this stop. That is not obstruction. That is my constitutional entitlement. The confrontation was intensifying. Other customers were beginning to observe. Some decelerated to watch. One woman extracted her phone and commenced recording from approximately 20 feet distant. I am not going to request again, Hutchkins stated. Move away from the automobile and supply identification. Kesha reached a decision. She would submit under objection, document everything, and address this through the appropriate legal channels. She had served as a judge sufficiently long to understand that disputing with police in parking facilities was perilous, particularly for Black Americans. Officer, I am going to submit to your demand, but I want to declare explicitly that this stop lacks reasonable suspicion and breaches my Fourth Amendment entitlements. I am reaching for my wallet presently to retrieve my identification. She moved gradually, intentionally. Her hand remained visible. She reached into her purse and extracted her wallet. Inside was her driver's license, her federal judge identification, her courthouse security credentials, her California bar card demonstrating she was a licensed attorney. She handed Hutchkins her driver's license initially. Hutchkins examined it. Kesha Langford. The address corresponded with vehicle registration he could observe through the windshield. This your automobile? He inquired. Yes, demonstrate it. Kesha raised the key fob and pressed the lock mechanism. The automobile's lights illuminated and the locks engaged. She pressed unlock. The lights illuminated again and the locks disengaged. Satisfied? She inquired. Hutchkins should have expressed regret and departed. He had detained someone loading their personal vehicle with their personal belongings. There was no offense, no violation, no reasonable suspicion. But Hutchkins had a difficulty. He had initiated this stop before witnesses. He had intensified the confrontation, and retreating now would appear like weakness. So, he intensified further. You are being belligerent and uncooperative. I am going to require you to remain here while I verify this data. Have you ever been detained by law enforcement for executing absolutely nothing improper? Type yes or no in the comments. Kesha experienced her anger escalating, but she maintained it controlled. Officer, I have supplied identification. I have demonstrated ownership of the automobile. There is no legal foundation to prolong this detention. Am I free to depart? No. You must wait while I process your data. On what basis? On the basis that I am conducting an investigation. An investigation into what offense? Hutchkins did not respond. He walked back toward his patrol automobile with Kesha's license. Kesha stood adjacent to her Mercedes, hands visible, waiting. She glanced at the woman who was recording and provided a small acknowledgement. Keep recording, the acknowledgement communicated. This is significant. Hutchkins sat in his patrol automobile processing Kesha's license through the database. It returned clean. No outstanding warrants, no criminal background, perfect driving history. The registered proprietor of the automobile matched the license, everything validated. Hutchkins should have returned the license, expressed regret for the confusion, and permitted Kesha to depart. But he had a larger difficulty now. He had initiated a defective stop, and prolonged it beyond the point of reasonableness. He required to discover something to validate his actions. He exited his patrol automobile and approached Kesha again. Ma'am, I am going to require to search your automobile. Kesha's eyes constricted. On what foundation? I possess reasonable suspicion that there may be stolen merchandise in the automobile. Based on what? I possess receipts for everything I acquired. The bags originate from establishments in this shopping center. Your reasonable suspicion is based on what particular articulable facts? Hutchkins was ensnared. He possessed no facts. He possessed a vague, suspicious individual report and his personal assumptions. That is not reasonable suspicion. That is not probable cause. That is prejudice. Ma'am, you are being uncooperative. That provides me reasonable suspicion. Kesha nearly laughed. No, officer, it does not. Asserting my constitutional entitlements is not evidence of criminal conduct. Arizona versus Johnson establishes that explicitly. You cannot utilize my refusal to consent to a search as justification for reasonable suspicion. Hutchins's face reddened. Are you an attorney? I am a federal judge. The parking facility seemed to become silent. Even the ambient noise of traffic and customers seemed to diminish for a moment. Hutchins stared at her. You are a what? A federal judge? United States District Court, Southern District of California. I have been on the bench for 19 years and you have just breached my Fourth Amendment entitlements in a manner that is so clearly established that you will not be able to assert qualified immunity. Hutchins's hand withdrew from his weapon. His posture transformed for the initial time since the encounter commenced. Uncertainty traversed his face. I require to see verification of that. Kesha reached back into her wallet and extracted her federal credentials, the official United States Court's identification with her photograph, her name, her designation, and the seal of the federal judiciary. Hutchins accepted the credentials and examined them. His hands were trembling slightly. This could be counterfeit, he stated, but his voice had forfeited its authority. Contact the federal courthouse. The main telephone number is public. Request chambers. They will confirm my identity. The woman who had been recording spoke aloud from her position 20 feet distant. I have got all of this on video, she announced. Everything. Hutchins glanced at her, then back at Kesha. Ma'am, I am going to require you to move away from the automobile. We are beyond that point, officer, Kesha stated calmly. You have already detained me unlawfully. You have prolonged the detention beyond any reasonable time frame. You have requested a search without probable cause, and presently you are intensifying because you have recognized you committed an error. What you should execute right now is return my identification, express regret, and contact your supervisor. I do not have to execute anything. Actually, you do, because I am not merely going to submit a complaint. I am going to submit a federal legal action. And every determination you make in the next 60 seconds is going to be evidence in that legal action. Hutchins made his most detrimental decision of the day. Instead of de-escalating, instead of contacting a supervisor, instead of acknowledging the error and attempting to minimize the damage, he determined to assert his authority. Ma'am, rotate around and position your hands behind your back. You are under arrest for what? Interfering with the police investigation. There is no investigation. There is an officer who observed a black woman in an expensive automobile and made assumptions. But if you are going to arrest me, execute it. The video is recording. My credentials are in your possession, and you are preparing to make the most significant error of your professional life. Do you believe the officer should have simply expressed regret and walked away at this juncture? Inform me below. Hutchins extracted his handcuffs. Kesha rotated around gradually. She positioned her hands behind her back. The metal restraints clicked around her wrists. The woman recording the incident was conversing on her phone presently, presumably contacting someone. Other customers had stopped to observe. A small assembly was forming. What is transpiring? Someone inquired. The police are arresting a federal judge for loading groceries into her personal automobile. Another individual responded. Hutchins escorted Kesha to his patrol automobile. She did not resist. She did not dispute. She simply walked calmly. Her head maintained high, her expression indecipherable. He positioned her in the rear seat of the patrol automobile. The plastic seat was rigid and uncomfortable. The automobile smelled like stale coffee and the chemical cleaning solution they utilized on the seats. Kesha sat perfectly motionless. Her mind was already functioning through the legal strategy. What claims to submit, what evidence to preserve, what witnesses to contact. Hutchins entered the front seat and sat there for a moment. He retrieved his radio, then returned it, retrieved it again, returned it again. He understood he had committed an error, a catastrophic error, but he had committed to the arrest. There was no method to reverse it presently without appearing incompetent. He initiated the automobile and drove to the police station. The drive consumed 11 minutes. He did not utter a word. Kesha did not either. When they arrived at the station, Hutchins brought Kesha inside. Other officers glanced up from their duties. They observed a well-dressed black woman in handcuffs and did not consider much of it initially. Hutchins transported Kesha to the processing location. A female officer named Carmen Rodriguez was assigned to process her. Rodriguez was a 12-year veteran who had witnessed everything. Rodriguez commenced the standard booking procedure. Personal belongings removed and catalogued. Phone, keys, wallet, jewelry. When Rodriguez opened the wallet, she observed the federal judge credentials immediately. She examined the identification card, examined Kesha, examined Hutchkins. "Where did you arrest her?" Rodriguez inquired quietly. "Parking facility of the shopping center in La Jolla." "What was she executing?" "Loading shopping bags into her automobile." Rodriguez's expression did not transform, but her eyes became intense. "What were the accusations?" "Interfering with an investigation." "What investigation?" "Suspicious individual report." Rodriguez raised the federal credentials. "Did you verify these? I believe they might be counterfeit." Rodriguez had processed thousands of arrests. She had witnessed every variety of counterfeit credential that criminals could manufacture. These were not counterfeit. The holographic seal, the microprinting, the weight and texture. These were authentic federal court credentials. She moved away from the processing desk and walked directly to her watch commander's office. Lieutenant Marcus Freeman had been with the San Diego Police Department for 21 years. He had managed difficult situations. He had managed controversial arrests. But when Rodriguez walked into his office holding federal judge credentials, his stomach descended. "Where is the individual these belong to?" Freeman inquired. "Processing location." Hutchkins brought her in, arrested her for interfering with an investigation. Freeman stood immediately. He walked to the processing location and examined Kesha, sitting calmly in the holding chair. He examined the credentials again. He walked to his office, closed the door, and initiated a phone call. The call went to the duty assistant chief. The conversation lasted 3 minutes. When Freeman disconnected, he appeared like he had aged 5 years. He walked back to the processing location. "Judge Langford, I am Lieutenant Freeman. I express regret for this situation." "You are being released immediately." "What was I being accused of?" Kesha inquired. "That is being reviewed. I want everything in written form. The initial call report, the body camera footage, the dashcam footage, the booking report, Officer Hutchkins' written statement of probable cause, everything." Freeman acknowledged. "We will have those prepared for you. How long will that consume?" "We can have digital copies prepared within 24 hours. I want them tonight." There was no space for negotiation in Kesha's voice. Freeman recognized the tone. He had heard it in court previously, the tone of a judge who had delivered a ruling and expected compliance. "I will make certain you have them tonight." Kesha was uncuffed. Her belongings were returned. She was escorted out of the station by Lieutenant Freeman himself, who expressed regret 3 additional times before she entered the Uber she had summoned. Kesha arrived home at 6:47 in the evening. She had been detained for 2 hours and 33 minutes. She sat in her living room for a prolonged moment, processing what had transpired. Then she retrieved her phone and commenced making calls. The initial call went to the Chief Judge of the Southern District of California. The second call went to her longtime friend who practiced civil rights law. The third call went to the American Civil Liberties Union. By Monday morning, the incident was being discussed at the highest levels of both the federal court system and the San Diego Police Department. The chief of police personally contacted Kesha to express regret. She listened politely and stated she would be submitting a federal legal action regardless. The legal action was submitted on Wednesday, 23 pages, single-spaced, with citations to Supreme Court cases and references to specific timestamps in the video footage and body camera recordings. The legal action alleged unlawful detention, unlawful arrest, violation of Fourth Amendment entitlements, violation of 14th Amendment equal protection entitlements, and racial profiling. It named Officer Hutchkins individually and the city of San Diego. The city attorney's office reviewed the case. They watched the parking facility security footage. They watched the body camera footage. They read the legal action. Then they contacted an emergency meeting with the police chief and the city manager. "This is indefensible," the city attorney stated bluntly. "We detained a federal judge for loading her personal automobile. The video demonstrates it explicitly. We possess no legal defense. We require to settle." But before settlement negotiations could commence, the narrative leaked to the media. Local news acquired it initially, then national outlets, then legal publications. Federal judge arrested while shopping became a headline that dispersed across the nation. The video from the woman in the parking facility was posted online. Within 24 hours, it had 3 million views. Within a week, it had been viewed over 15 million times. The comment sections exploded. Individuals shared their personal narratives of being profiled. Legal experts analyzed every violation Hutchkins had committed. Civil rights organizations utilized it as evidence of systemic difficulties in policing. The San Diego Police Department opened an internal investigation. They assigned their most senior internal affairs investigator to the case. The investigation consumed 4 weeks. They interviewed Hutchkins multiple times. They reviewed every second of available footage. They analyzed the suspicious individual call that had initiated everything. The findings were condemning. The suspicious individual call had been initiated by a shopping center security guard who had subsequently admitted he believed Kesha appeared out of place near expensive automobiles. When pressed on what that signified, he could not articulate any particular suspicious conduct, simply a sensation. Hutchkins had responded to that vague call and immediately focused on Kesha based on race. He had detained her without reasonable suspicion. He had prolonged the detention beyond any reasonable time frame. He had requested a search without probable cause. He had arrested her for asserting her constitutional entitlements. Every single action he executed was a violation of department policy and constitutional law. The investigation also discovered patterns in Hutchkins's background. Over the previous 3 years, Hutchkins had initiated stops involving black motorists at a rate 2.8 times higher than the department average. His searches of black motorists were 3.4 times higher. His arrest rates demonstrated similar disparities. The pattern had been present for years. Nobody had examined the data. Nobody had connected the correlations. Officer David Hutchkins was terminated 6 weeks after the incident. The termination letter cited multiple violations: unlawful detention, unlawful arrest, racial profiling, violation of department policy, conduct unbecoming an officer. Hutchkins attempted to appeal. His union representative reviewed the footage and informed him the identical thing everyone else was informing him. You are finished. The video is too explicit. The victim is too credible. The violations are too obvious. Hutchkins withdrew his appeal, but his termination was merely the beginning of the consequences. The Department of Justice Civil Rights Division opened an investigation into the San Diego Police Department's stop and search practices. They wanted to understand if Hutchkins's prejudice was isolated or symptomatic of larger difficulties. The investigation consumed 8 months. They analyzed 5 years of stop data. They reviewed thousands of police reports. They interviewed dozens of officers and community members. Their findings were released in a 97-page report. Black residents were stopped at rates significantly higher than white residents, even after controlling for crime rates and population. Black motorists were searched at rates 3 times higher despite being less likely to be discovered with contraband. The San Diego Police Department entered into a consent decree with the Department of Justice. The reforms were comprehensive: mandatory implicit bias training for all officers, early warning system for officers with problematic patterns, civilian oversight board with genuine authority, regular audits of stop data by race, body camera requirement for all uniformed officers, and federal monitoring for 3 years. Kesha's legal action settled 9 months after the incident. The settlement amount was never publicly disclosed, but sources familiar with the negotiations stated it was $675,000. Kesha donated the entire settlement to civil rights organizations working on police reform. I do not require the money, she informed reporters in her only public statement about the incident. I require the system to transform. I require other individuals who do not possess my resources and position to be protected from what transpired to me. The parking facility security footage became required viewing at police academies across California. It was utilized in constitutional law classes. Civil rights organizations utilized it in community education sessions. One 2-hour detention in a parking facility led to a terminated professional life, a $675,000 settlement, a federal consent decree. and systemic reforms that affected how an entire police department operated. David Hutchkins never worked in law enforcement again. His termination for cause made him unhireable to other agencies. He attempted private security employment, but could not maintain employment. He eventually departed California entirely. He provided one interview to a local news outlet, claiming he had been following his training and that the judge had been uncooperative. The interviewer inquired if he had watched the footage. Hutchkins stated he had. The interviewer inquired what particular suspicious conduct Kesha had participated in. Hutchkins could not respond. Kesha Langford returned to the bench. She continued presiding over cases, including several concerning police misconduct. Colleagues stated the experience made her even more attuned to civil rights issues in her courtroom. In private conversations with other judges, Kesha has stated that what transpired to her was not unique. It was simply documented. She stated thousands of Black Americans experience similar treatment daily, but they do not possess federal credentials, they do not possess legal knowledge, and they do not possess the resources to fight back. That is why she pushed for the footage to be made public and why she donated the settlement. So, the incident could become a teaching moment, so individuals could observe what racial profiling appears like. So officers could learn that assumptions are not evidence and prejudice is not reasonable suspicion. The security camera footage is still online. You can watch it yourself. You can observe a federal judge calmly asserting her entitlements while being detained for the offense of shopping while Black. You can observe the moment Hutchkins realizes what he has executed. You can observe what accountability appears like when the system actually functions. What is your most significant takeaway from this narrative? Post it in the comments below. And if this opened your eyes to the reality of racial profiling, make certain you are subscribed because we tell narratives that require to be heard. This narrative is significant because Kesha Langford possessed every advantage. She possessed legal knowledge, she possessed credentials, she possessed position and authority. And she still became handcuffed in a parking facility for loading shopping bags into her personal automobile. Consider everyone who does not possess those advantages. Everyone who becomes stopped and searched based on assumptions. Everyone who becomes arrested for asserting their entitlements. Everyone who does not possess the knowledge or resources to fight back. Kesha's narrative demonstrates that even when you possess every advantage, prejudice can still affect you. But it also demonstrates that accountability is possible, that the system can function, that consequences can follow violations. Not every unlawful detention concludes with justice. Not every case of racial profiling leads to termination and reform, but this one executed, and that is significant. Thanks for watching this narrative all the way through. If this made you think differently about police accountability and racial profiling, share it with someone who requires to observe it. Press subscribe if you have not already. We are going to keep bringing you narratives that are significant. Post a comment. Do you believe $675,000 was sufficient? What would genuine accountability appear like? Observe you in the next one.